SJC-12599, Pembroke Hospital v. DL.
Morenstein, you may begin.
Good morning, Justices of the Supreme Judicial Court. Good morning, Chief Justice Gantz. My name is Devorah Borenstein, and I represent the appellant, DL. 10 years after this court's decision in Newton Wellesley Hospital versus Magrini, we're back. And we're back because a hospital's conduct of refusing to give DL his lawful freedom and instead re-restraining him after the court denied the commitment petition rendered that denial illusory. There are three fundamental rights at stake in this appeal. One, the right to regain one's liberty through an actual physical release after a court denies a commitment petition on the merits.
Does it matter that circumstances changed after the court made its decision?
Your Honor, circumstances actually did not change.
Okay, but I'm talking about the grandmother saying that she didn't want him to come live with her. So tell me where I'm wrong here. There was testimony that it would be safe for him to go live with his grandmother. There'd be no problem with that. And then after the hearing, after the decision, it turned out he could not go live with his grandmother and he was not going to have anywhere to go. Isn't that a change?
The testimony that Your Honor is referring to was from Dr. Rizal, who on direct said there is no less restrictive alternative. That was his testimony. It was on cross-examination when counsel for DL asked him, can DL go back to grandmother's house? And he said, caveat. We have not been able to speak with grandma or the other relatives because DL has consistently refused to give us a release.
Okay.
And after asking him one more time, do you have any reason to believe that he couldn't go back? The doctor answered, I don't have any reason to believe. But that was a negative answer. That wasn't based on any information.
So it's not as if the court was taking into consideration the fact that he had someplace to go, necessarily.
The court heard all the testimony and determined that there would be no likelihood of serious harm if DL were discharged into the community. The court heard all of the evidence, including the evidence about grandma, but the prong that was being pled here was the third prong, which, as Your Honor knows, is a very substantial and imminent risk of physical impairment or injury, as evidenced by the person's judgment, which is so impaired that he can't protect himself in the community. And the second element is, and there is no reasonable protection in the community. The judge didn't have to get to that second element because the judge determined, after hearing all the evidence, that there would be no likelihood of serious harm if discharged.
But let's go back to the premise of Justice Budd's point, if we could, though. I mean, I did these hearings as a district court judge, and it really bothers me that I'd finish at Bay Ridge at 12 and that someone would be gone at 12:10. I get it. That, they're going to Section 12 them because they didn't like the decision. So you're raising a really important point. But what if, so take the premise of Justice Budd's question. So let's say that the doctor testified otherwise. Say the doctor testified, well, no, I think he'd be okay, but only if the grandmother was able to take him in, and we haven't any HIPAA problems. We've been talking to her, and everything's fine. So, but without that, it would be a real problem. And the judge makes the decision, and then 10 minutes later, you find out that the grandmother isn't going to take the patient back because she thinks he's still psychotic. What about that?
Well, I believe, Your Honor, in those circumstances, only if the court had conditioned its denial of the commitment petition on DL going home to the grandmother, would there be a reasonable argument that circumstances did change or a new event occurred.
I know, but, this case is moot, and that's the first thing we're going to hear when the other side argues. And so if we're going to decide the case, there's a bigger principle than the minutia of this particular case that we're dealing with. So the question, the whole question is, well, what if the circumstances really changed? The judge is back to first session in the Lynn District Court, and 15 minutes later, you got a different world of the person in front of you. Is there some flexibility? Is there some ability for the psychiatrist at the hospital to say, well, this is a whole different situation. I've got to do I've got to do a Section 12 here.
I believe the psychiatrist would, under certain limited circumstances, have the ability to resection the person, but what I'm arguing is that those circumstances need to be narrow, particularly where a court, as in this case, has denied the petition on the merits. And as soon as a court denies the petition, the hospital no longer has authority to hold the person under Section 6. That person has to be able to leave the hospital freely. And as Your Honor knows, most of our cases are heard in hospitals. If the cases were heard in a courthouse, as soon as the judge denies the petition, that person's free to put on his coat and leave. But unfortunately, when we're talking about a hospital, the circumstances are different.
I'm confused, though. Back to Justice Budd's question, though. The original focus is on whether he's starving himself to death, right?
Correct.
Then your predecessor, I don't know if you were trial counsel or not, but then you probe the issue of whether he could go home to grandma, and the doctor doesn't know the answer to that. But is when the judge decides in your favor on the starving point, is that an implicit finding that he could go anywhere?
Yes, it is, Your Honor.
And how do we know that? Because that seems to me, what happens is the doctor is focused on the fact that he thinks he's a danger anywhere. The judge rejects that. Then they are confronted with the grandmother not being there. And I'm just wondering, is there really an implicit finding that he can go anywhere? I don't, and what directs us to that?
I believe there is, Your Honor, because Section 8A says that a court shall not order the commitment of a person unless the court makes two particular findings.
Right, but we're dealing with the opposite when the court says that you shouldn't commit them, right? They're saying the court here rejects this initial premise. And does that mean that they've made a finding that he can go anywhere? Because I just don't understand that exactly. I understand when they when they say there's no less restrictive, if he had decided the other way and said there was he has to be in the hospital, but he doesn't make that determination.
The court is unable to make the two required findings under Section 8A, and therefore the court may not enter a commitment order. And the court actually says that in the record. I find that the hospital did not meet its burden. DL is eating and drinking. Therefore, I'm not going to order an ongoing, it ends there, but I believe the court meant to say an ongoing commitment. At that moment, there's no more authority to hold DL.
Can I ask you about the recommitment aspect of it? And I think what you appropriately concede is that if there was new information, there could be a second Section 12, correct? So if they were releasing this person and he expressed suicidal ideation or something happened, there's a psychotic break, something happened, you don't argue that he has to be released because there could be a new Section 12, correct?
Correct, but if I
Okay.
can qualify that.
Yeah, no, I just want to get from you
Yes.
how we should write that if we agree with you, right? Because what I'm trying to figure out is how we don't tie the hands, because the premise of your argument is that this mental health professional did not agree with the judge's finding, flouted the judge's decision, and had him recommitted to the emergency room, or had him sent to the emergency room, which ultimately led to another Section 12, right?
Correct.
Okay, so help me try to tease out what we say on the ability of someone to re-petition
Well,
after a release.
Yes, well, I think what we're dealing with here is that moment in time after the court denies the petition, up to the point in time where the person's actually leaving.
Right.
And that's the problem for us. What I would say is, first, the rule is that after a court denies a commitment petition on the merits, the hospital must immediately release the person and restore his liberty. Where a person has not yet been released, in order for a clinician to be able to resection that person, there must occur a new event that provides a new and independent basis for a reasonable belief.
Supposing that happened, would your doctor have been able to reapply or apply again in Pembroke or in front of the same judge? Could they have kept the patient at the Pembroke emergency room?
Is Your Honor, may I clarify?
Sure.
Is Your Honor asking me if an event had occurred after the
Right,
court had denied?
yes.
Yes.
So they could have stayed in the same place.
They wouldn't have to go to the emergency department.
Yes.
They would or would not have to go.
Well, if there were an event that occurred after the denial of the petition, but before DL reached the front door of the hospital, and there was a reasonable belief under 12A, I would say, yes, the hospital doctor would have had that ability to file a 12A, and I would assume that the doctor would seek admission at his own facility. In this case, it didn't happen.
And the problem with this case, you argue, is that the new event that Grandma won't take him back wasn't part of the judge's ruling to deny the petition.
No, I'm
Was
saying,
it, yeah, so if the judge had said, your petition's denied because this person is going to be able to live with the grandmother, they're gonna be stable, et cetera, and then it turns out that's not the case, then that could be a new event.
correct. If the judge had found harm under the first element of the third prong, but then determined that there was a less restrictive alternative, and that was grandmother's house, and then it turns out that she's unavailable for whatever reason, I would, yes, concede that that would be a new event because the judge specifically conditioned his findings on the availability of grandmother. But again, this wasn't this case, and the reason why it's not this case is because the issue about grandma is actually, it's irrelevant, because once the court found no harm, we don't even get to less restrictive alternative.
Is there a, I know there's a process, and you do this work. When a petition's denied, is the person processed? Is there some time lag that is inherent in this before they're allowed to walk out the door?
Unfortunately, yes, Your Honor. As most of our cases are heard in the hospitals, there is, for some reason, a lag time. I'm arguing there shouldn't be. The person should be allowed to literally put on his coat and leave. But they are often reprocessed and subject to this kind of abuse or misuse. Because
Do they at that point make sure they have their medication and a place to go, or do they just say, okay, see you, and let them walk out the door?
Yeah.
in most cases, I believe it's a range, but I believe that in most cases, there is some kind of processing that goes on, discharge planning. I'm arguing that the discharge planning really should be done prior to the hearing because a hospital should be prepared that it can lose.
But yeah, I mean,
Yeah.
I think we would want the hospitals not to release people if they had to have meds and they had to have a discharge plan. We would expect any mental health professional would want to, just like anybody that goes to emergency room and you're discharged, you shouldn't be kicked out. You should be saying, well, go see your primary care, here's your medication. I don't think that's unreasonable.
It's definitely not unreasonable, Your Honor, but I guess the problem is that after the hearing is over and we have this lag time, some people might want to leave immediately, and there's an exposure to more abuse
So
or
you're saying
misuse.
there's an exposure to new events arising. That's what your fear.
They're exposed to what Pembroke has qualified as new information. Anything could be new information, and that's the problematic piece. It shouldn't just be new information, because it could be, oh, we didn't know X, Y, and Z, we just found out about it. And that all needs to be consumed by the original litigation because it's an adversarial proceeding. The hospital should be preparing for it. And because it's a strict timeline, the civil commitment statute, there's a beginning with Section 12 and it ends with a judicial determination that the hospital has or has not met its burden of proof. It needs to end there. So if there is a resection, it needs to be clean. It needs to start with some new event, and it can't rely on old facts that were actually part of the original litigation.
So this is obviously this is not the Newton Wellesley Hospital versus McGreeny case where it's clear that time ran out and then they're using Section 12 to make up for not filing the petition on time. But I'm in the same place where Justice Gaziano is trying to figure out what happens during this interim period to make sure it's just not the doctor's appeal from the judge's decision not to deny the petition, because we can't have that.
Yes.
And so, what does this look like? I mean, maybe this case isn't that hard, because if you look at the transcript, the cross-examination was really short, and the doctor never said anything about the grandmother being, a good place to live. With something like, well, I don't really know, we couldn't talk to her, but sure. And so what if it's not that situation? What if it's this area that Justice Gaziano's talking about, that's sort of in between when the hospital's just doing the right thing, trying to help the person go on with his or her life for a couple of minutes, and something really does happen?
Well, if something really does happen, then the clinician does have that authority under Section 12A. What we are saying is that there has to be a new event that it happens after the hearing, and there has to be some kind of elevated good faith on the part of the clinician. Otherwise, we find ourselves in these situations. But really, if the person wants to leave immediately, there shouldn't have to be any discharge planning, because he has the right to leave. There is no authority under the statute to hold that person 1 second longer. So the rule should be that the hospital must physically release the person from the hospital. If the person wants to engage in discharge planning, he's free to do so. But he has to be able to freely leave the hospital, which was not the case in DL. And then afterwards, if there is an event that occurs between the time that person is walking out and reaches the door of the hospital, 12A would kick in, but there would have to be a reasonable belief, which did not exist in this case.
If I can flesh out your new event, I'm trying to figure out if I understand you correctly. Where the judge finds, as he did here, that there was no likelihood of harm, am I correct in understanding that your new event would have to be new conduct by DL? Something, him doing some suicidal conduct or him acting out in some way which would cause somebody to be appropriately revisiting the judge's finding that there's not a likelihood of harm.
Yes, I would agree. And I also believe that we're not very far apart with DMH's position, actually, on, I believe, page 21 of the amicus brief that DMH submitted. DMH talks about the person acting out in a suicidal manner or causing some serious bodily harm. So we agree on that point.
Okay, so if the judge had found there is a likelihood of harm, but there is a less restrictive alternative, that is live at grandmother's house, does the judge, by the way, make it conditioned upon that, or is it just you're released based on the finding that there is a less restrictive alternative?
I don't believe that the judge can actually condition. This is an open question. I think it's straight up or straight down. The judge either denies the commitment petition or orders a civil commitment. But theoretically, a judge can make a finding. I find harm under the first part. In the second part, there is, however, a least restrictive alternative. In this case, it's grandmother's house, so I am going to deny the petition. And so if somehow between that point in time and DL, or the person leaving the hospital finds out that grandmother, whoever is taking in this person, is no longer available, because of the judge's finding, I would say, in that case, that would constitute a new event.
So what makes this new event not a new event, according to you, is that the judge did not did not reach the issue of less restrictive alternative.
Correct.
And if he had said there's a less restrictive alternative, he live at grandmother's house, and therefore I release him, and then the hospital were to determine, grandmother says, I won't have him, then that would be a new event which would permit them to 12A, to do a 12A. That's what is that what you're telling us?
Yes.
So the new event need not be the conduct of the defendant, it's only the conduct, not the defendant, conduct of the petitioner, whatever, only when there's a finding of no likelihood of harm. Then it would have to be the conduct of the individual, but it could be the conduct of third parties, where the third party is the reason why there is a less restrictive alternative.
Correct.
Okay, thank
If there
you.
are no other questions from the bench, then I will rest on my brief. Thank you.
Okay. Mr. Porter.
Morning, Mr. Chief Justice, Associate Justices. May it please the court, I am Michael Porter, and I represent Pembroke Hospital. Your honors are asked to address two questions in this case. First is whether Pembroke Hospital in fact discharged DL subsequent to a denied petition for his civil commitment, which took place on December 30th, 2015. Your honors are also asked to answer a question on whether Pembroke Hospital had the legal authority and ability to readmit DL the following day. And it is the position of the hospital that your honors should be answering both questions in the affirmative. The commitment hearing that took place on December 30th before Judge Kirkman, the judge heard the following evidence, that DL was 23 years old, that the circumstances leading to his admission were that he had made suicidal statements to his mother, both via phone as well as text.
I think we can maybe dispense with the facts because we've read the record, but if we get to what happens after the judge denies the petition, so this was done at the hospital?
It was not, Your Honor. This was done at Plymouth District Court.
At the district court. So the judge makes a ruling in the district court. DL is then transported back to where he came from, to Pembroke.
Respectfully, DL did not, he chose to absent himself, so he was not present at the hearing.
Okay, all right. So DL is still in Pembroke.
That's correct.
The order comes down, right?
Yes.
And then the clinician starts to inquire of the grandmother, tries to get information.
Dr. Rizal, upon the denial of the petition, had been working with hospital staff rather than flouting the court's decision to deny the petition. Instead, worked to effect this discharge. Within that, it is based on the doctor's assumption at that time, as well as what had been testified to before the trial judge, that it was the assumption that DL, who had been living with his grandmother in the time immediately preceding the admission, would in fact be able to return there.
But your sister says that you don't get to this less restrictive issue unless you've got a finding that he's in danger of harming himself, and the judge says he's not, so we don't even consider placement. Do you agree with that or disagree with that?
I agree with the interpretation of the judge's decision. What the judge established was that he had a reasonable doubt and that's it. And so we must intuit the basis for his decision. And the only way that we can do that is to take the totality of all the evidence that's
Doesn't he?
before the court.
He makes a statement. I mean, it's one paragraph in the transcript that you've attached, but he says, I don't think, he's eating, so I'm not worried about it.
I believe that the judge said he's eating some, he's drinking some, and therefore I have a reasonable doubt, therefore I'm not going to extend this order of
So
commitment.
then why do we read in this less restrictive alternative issue? I thought, again, I'm trying to understand that first and foremost. If the judge says he's not going to hurt himself, why are we looking at this less restrictive option, and why should we assume that figured into this?
Because, again, based on all of the evidence, since the judge is not required to enter findings in the commitment proceeding, he merely, again, to highlight my sister's characterization, it's up or down. He either allows the petition or he denies it. And so because all he's required to do is just do one or the other, since he denied it, we have to look to see what is the information that he's relying upon to determine whether what created that reasonable doubt to allow
How do you
the
get to
discharge.
how do you get to do that? Because, and I'm not saying that what the clinician did was not reasonable, and these are very difficult situations. But once the judge denies the petition, doesn't DL have a constitutional and statutory right to liberty? That he has to, whether your clinician likes it or not, he has to be released.
Yes, and by operation of law, he's required to be
Under
discharged.
Section 6, you can't hold anybody.
That's
Unless
correct.
they're in legal custody.
That's correct. And I guess just to highlight the comprehensive nature of Chapter 123 itself, the actual denial of the commitment petition, there's no order that the patient be discharged. It's just that the petition has been denied. So then you have to look to a different section
Right,
to
which says
see
you
that
can't-
you
you
need
can't
to have a
keep-
legal status in order to be a patient. So since you don't have a legal status, you're no longer a patient.
Right.
And so the doctor...
So all the aftercare and all the, I need to see the follow-up stuff, the argument by DL is that was simply none of your business once he was determined to be free, and he had to be released, whether or not Grandma was able to pick him up.
That's correct. But in the sound
Now, in
clinical
what-
opinion of Dr. Rizal, in his attempt to have him discharged, contacted the grandmother. He had lived with her from before. She had visited him during the admission. There was no indication that she wouldn't take him, although the doctor had testified that he had reservations on his safety. Nevertheless, he was required to discharge him, and so the doctor continued on with his other competing yet equally significant obligation to ensure that he's safe. So if there were no information at all whatever where DL had lived in the time immediately preceding the admission,
And where does that obligation arise? There's a doctor-patient relationship, correct?
correct.
And just like anybody else that leaves an emergency room with aftercare, are you saying that because there was a doctor-patient relationship, that he had an obligation to do this aftercare?
I'm saying that the obligation would be at least twofold. One would be professional ethics, and the other would be the licensing component of the Department of Mental Health within their regulations requiring that all efforts be made so that a person, I presume similarly situated to DL, would not just simply be shown the door and that's it. And to the court's earlier...
Particular regulation you can refer us to? That, because, I mean, the chief's question earlier about this wasn't a less restrictive alternative finding. We don't have that. So aren't you building in through this regulation a less restrictive alternative finding? And
Not
it's-
at all.
Okay,
Not
so-
at all, because if we could just change the facts just a bit, and we have a geriatric patient at another psychiatric hospital, and there's testimony that in the past, this geriatric patient had been able to be maintained in a nursing home. And it's the doctor's belief that that patient, even though he probably wouldn't be safe, could go back to that nursing home. Doesn't convince the judge beyond a reasonable doubt that the nursing home would be unsafe, and then once that petition is denied, come to find out, that person cannot go back to that nursing home. So it's a finding based on the totality of all the evidence.
Again, you're left with a problem here, which is he's supposed to be released, and he's got a constitutional right to be released, right? And then you're finding some grounds.
We need a legal basis for the discharge in a safe manner
Yeah.
component that you want us to impose.
The legal basis is founded in the factual basis because DL was no longer under the control of Pembroke Hospital.
Right.
The hospital had relinquished its control of DL, but based on additional and new information that had come to the doctor's attention after the judge had denied the petition for commitment, that it was then and only then that he had sought an independent determination on the appropriateness of
I'm
hospitalization.
not sure
So
that the
it's a
record,
fact.
I'm not sure the record reflects that. Cross-examination, but doctor, you have no reason to believe that his grandmother would not allow him to move back. No, but the cross-examination again is he's asked, so could he go back? He doesn't say yes. He says it's a caveat. It's been very difficult for us because the patient has consistently refused to let us talk to the family. They don't really have any information about the grandmother, and
If you read on, Your Honor, within that transcript, it does ultimately have Dr. Rosales answering a question that it's his opinion that DL could go back to live with the grandmother.
So do you agree with counsel for DL that his recommitment would take a new event or independent basis to file another Section 12A?
No, Your Honor, and the reason being is that there's no dispute that if DL had just walked outside of Pembroke Hospital.
They're asking for the constitutional right to hit the street, essentially.
That's correct. And if he had hit the street, if he had happened upon some independent clinician, independent of the commitment hearing itself, there is no preclusion for that other clinician upon evaluation that if that clinician believes that failure to hospitalize creates a likelihood of serious harm, there's no prohibition to having him rehospitalized.
I agree with you, and that's why you sent him to the emergency department. But I guess the problem is that you being Pembroke, arranged for him to go to the emergency department, transported him to South Shore Hospital, correct?
That's correct. And although
There's no break in his physical, and it may seem trivial or absurd, but if you had opened the door, he had walked out, and an emergency physician from South Shore Hospital was walking down the street, they could have sectioned him, correct?
that's correct.
But instead of that, he never saw the light of day. He was taken, his liberty was still deprived because he was taken from Pembroke Hospital, transported to South Shore Hospital, right?
And if there were prohibitions to the assessment of appropriateness of admission found in either 12A or 12B of Chapter 123, then the hospital would have done that. And although it is not, it does not carry the day, I do believe that it's persuasive that the appellate division had recently decided that in the matter of EA, that it defies logic to just simply allow somebody in the community to their own devices, when in that case, they had been escorted, the person in that appellate division case was essentially not free to leave, escorted across the street. They had been reevaluated. It was determined that it was appropriate, at least in that other clinician's assessment, that hospitalization prevented a likelihood of serious harm, and then a new 12A resulted in a 12B admission.
But he was not free to go. He was never free to go, was he?
The requirement is
Try
that
my
he be
question. Was
discharged.
he ever free to go?
No, he was not.
So he was formally discharged, but he was never free to leave.
The hospital acted in accordance
Okay,
with
I know
the
that's your
statute.
position, but is your position then that upon a judge's declaring that someone is released, the hospital can just send them to another hospital until they get a judge who will say, I'm going to agree with the doctor?
No, absolutely not. And
What happened here? I mean, your sister says there's this distinction between a likelihood of harm and a least restrictive alternative. Do you agree there's that distinction?
I agree that there are 3 different elements for a commitment
Okay,
case
and do
to
you
be
agree that
allowed.
you don't get to least restrictive alternative unless there's a finding of likelihood of harm?
And respectfully, I believe that there's no requirement of the trial judge to enter any kind of findings whatever. The judge
I
could have.
understand that, but logically, do you reach the issue of least restrictive findings if there is not a likelihood of harm?
Usually in a commitment case, Your Honor, there is a combination of the two. A person could be safe in one setting and create a likelihood of serious harm in another. And so it is often not a distinction that the facts would allow for, and yet still meet the burden of proof.
So is that something we should require judges to do? To basically make findings as to whether there is a likelihood of harm, and if the answer is no, he's released, and if the answer is there is a likelihood of harm, but there's a less restrictive alternative, that would affect the event that could be used to recommit him.
I believe it would be difficult for trial court judges to fulfill that responsibility if there were to be a new one, only because it would potentially appear to be conditioning discharge on particular placement. So, for example, if the trial judge had explicitly said that DL could be discharged to his grandmother's, and again, according to the facts, there was testimony that the father was called when the grandmother refused to pick him up. Does that mean now that the hospital would be precluded from discharging DL to the care and custody of the father? Or in a different set of facts, if the grandmother were unwilling or unable to take DL, yet Dr. Rizal, changing the facts, felt that even though it's not the best of ideas, that DL could be discharged to a shelter setting, does that prevent that from happening? So I think that it would be causing more problems than what it would attempt to address.
But the only reason that Dr. Rizal held him was because the grandmother wouldn't take him.
The reason why Dr. Rizal sought an independent assessment of the appropriateness of hospitalization was because with this additional factor that overrode what he had been under the impression prior, that this would cause him to be unsafe irrespective of his responsibility, which he fulfilled.
Okay, so if
to
the
have him
grandmother had said, I'll take him, he would have released him. He would have
Yes,
had
Your
no
Honor.
basis. So
And
the only,
would he
the
been
only
able-
basis is because the grandmother said, I won't take him.
That's correct.
How did he fulfill his obligation to discharge?
Because he didn't say, not only do I disagree with this, I'm going to bypass any type of appellate route that a hospital may have, which I don't think that we would have, but in any event, I'm going to keep him anyway.
So
So
if he had kept him at Pembroke, he would not have discharged his obligation. He would not have fulfilled his obligation to discharge. But by sending him to social hospital, he fulfilled his obligation.
it's the the underlying action that he undertook and had staff at the hospital undertake that I believe fulfilled the responsibility, because he had tried to get him a safe place to go, transportation to that safe
And I don't
place.
doubt the good faith of the doctor or his clinical judgment, but we're dealing with a statute and a constitutional issue. And I'm just trying to get my arms around the ability of a doctor to discharge in a safe manner versus the liberty interest that the statute seeks to protect.
And that is a critical role for not only the courts, but also for psychiatric hospital clinicians.
Speaking of the courts, do you agree with Attorney Bornstein that had this patient been at the courthouse, he would have been permitted to just walk out the front door?
That's correct. And I've actually been counsel for a petitioning hospital where that very thing happened. And again, to Your Honor's point earlier with the question of, well, we want to make sure that they have the right medications all lined up, they have aftercare appointments. In that particular scenario, the patient said, well, I don't want to go back to the unit, respectfully. I don't even want to go gather my belongings. I just want to leave here.
So-
The hospital,
so-
since
so
it
the-
had no authority,
So the fact that it's not, I mean, Justice Cyphers, so if it were court, you're off the hook? Is that, I mean, you have some kind of duty because he's still in the hospital? Is that, and where does that duty come from?
the rights and responsibilities for the patients as well as for hospital staff are found within Chapter 123. And the hospital would have no right to retain somebody involuntarily
He's no longer your
unless he has a legal status.
Right, he's no longer your patient at that point.
That's correct. However, in the situation where you have a hearing that's going to take place at a courthouse rather than at the facility, if the patient were to acquiesce to transportation to go back to the hospital to facilitate a discharge plan and to gather his belongings, then there's no hospital that I know of that would just turn him away.
But I don't get it. That's what I don't understand. If he's at the courthouse and he got this order, he gets to walk whether grandma shows up or not, right?
Correct.
So because he's at your hospital, what is it that allowed that doctor? Is there a regulation that says you cannot discharge someone into an unsafe place? Or is there what, I don't get what legal authority, I still don't find the legal authority.
It's
for-
respectfully, it's the explicit language within subsection 12A of Chapter 123 itself. He is a physician who, based on his evaluation, believes that failure to hospitalize this person creates a likelihood of serious harm by reason of mental illness. It would run afoul of the
Even
judge's
though- even
denial
though-
of the petition.
Even though the court has just made the opposite conclusion.
That's correct, because of the additional information presented to him. Because he was operating on, I concede that it was a flawed assumption, but he was operating on an assumption that when it came time to effectuate the judge's order, which it's the position of the hospital that he clearly attempted to do, that it was at that point in time that not only did he remain psychotic, but that now he had no safe place to go, and he had no way to get there.
I read the whole transcript, and I still don't see it, as far as the doctor saying that he believes the grandmother is available. The best you have is she probably wants him to get better, yes, definitely, and you don't have any information that she wouldn't let him back. But and that's the best you have. That, I'm not sure that's what constitutes changed circumstance. But when we're evaluating what happened, just let me make sure I'm at the right place and time, that unilaterally, the doctor under Section 12 can make this decision. There's not an in-the-moment review. So it's either the patient requests an emergency hearing on the Rule 12, or it gets addressed, as it did in this situation, with the motion to dismiss at the next Section 7, Section 8. Is that right?
Yes, Your Honor.
So
and-
that's what we're looking at right now.
That's correct, and I highlight that because of the procedural protections that are put in place, and if you view the motion to dismiss as tantamount to an emergency hearing where the court was asked to address whether the denial of the petition, discharge, readmission, and refiling of a new petition to commit, if that was an abuse or misuse, then whether it's the emergency hearing request the DL did not avail himself of, or whether it's this motion to dismiss, there are procedural protections that are designed to adhere to any due process concerns. And if at the time of the motion to dismiss, or if it were an emergency hearing, which the court would have no discretion but to schedule and commence the hearing, and it would have to be the day that they receive it or the next business day, that if there was a determination by the court that this too runs afoul, then again, the hospital would have to discharge the patient. It's because of the new information that the doctor had over and above what he thought and over and above what had been testified to that causes this new situation to take this DL discharge from a situation where he has to leave the hospital versus what happened here, where he leaves the hospital relinquishes control. However, based on the concern, based on the enhanced likelihood in the doctor's opinion that he needs to be hospitalized, that's what makes it permissible to send him to that independent evaluation, which, by the way, the independent, there's no requirement that an application for hospitalization arise from South Shore Hospital. They could have taken DL, and they could have said, well, we don't think that his situation would cause a likelihood of harm if he were not hospitalized. But they did. And subsequent to the readmission at Pembroke Hospital, there was a judge who found beyond a reasonable doubt that DL, failure to hospitalize him, created a likelihood of serious harm. So the hospital acted permissibly, and the concerns for DL's safety had been borne out both by an independent clinician's evaluation as well as by the court
Yeah,
itself.
I think this is the concern, and my colleagues have been touching on it as well, is that, the hospital and the doctor, they're just trying to do the right thing afterwards. They want to make sure that the person's ready to leave. Now, of course, if the person wants to leave, they should be able to leave, and there was never that discharge moment in the hospital. But if they want to leave, they don't want to go through all that. I mean, part of what led to the changes with the legislation is the personal autonomy and respect for this individual. If they want to be homeless, they can be homeless. And we have to make sure that any agreed to post-care after the hearing is actually agreed to, and that the person's able to leave unless there's really some significant change in circumstance. And the concern here is there was never that sort of discharge moment. He just went from the hearing and sort of rolled into, let's send him to South Shore Hospital, and he's never really out of custody, that's the concern.
And again, if that concern were to have been raised through a request for an emergency hearing, then DL has immediate recourse to the courts. He also has immediate recourse to have a lawyer appointed to represent him. And although that was not the chosen mechanism, he nevertheless had sought to have judicial review of the overall factual basis for the admission, which includes the most immediate discharge based on the denial of the petition to commit.
Yeah, but fair enough. We've got to write something, and the doctor at the time of the Section 12 is not subject to review. They are with the emergency hearing that day or the next business day, and this area in between, right after the hearing, I guess, is the concern.
And I appreciate the court's concern. However, there's nothing in the statute that creates any type of limitations to rehospitalization based on time or space away from the facility.
So your position is that if he had come to the hearing, he could have walked out?
Yes.
Okay, but because but if the hearing were held at Pembroke Hospital, or if he chose not to come, he's in a very different status.
No, because if he had just simply chosen to leave, and the conversation would somehow go along the lines of, okay, Dr. Rizal, I know that you want to arrange for this transportation for me. I'm not going to wait around for this, and I know that you lack the authority to retain me here
But wait,
involuntarily.
start that conversation at a different place. How does he first learn that he's going to be allowed to leave?
If he were present at the hearing, and the
Present
hearing
at the
is
hearing,
at the hospital.
But if he's not at the hearing,
If he's not at the hearing.
Then
he
what
w-
happens?
Then he would be on the unit,
Mm-hmm.
and he would have the opportunity to just simply leave the hospital.
how would that happen? Would somebody inform him of the result of the hearing?
Practically speaking, I would tell the doctor, you have to discharge him right away. The doctor has to go to the clinical staff, usually it's the charge nurse in charge of the unit, charge nurse discharges the patient. If he is unwilling to remain, even for that one phone call, then the doctor no longer has this information over and above what he had been relied upon at the time of the hearing. He still would have left.
You're saying he voluntarily remained there while the phone call was made to his grandmother?
Yes. Or if I could parse that out, there's no information showing that he was desirous of leaving before the phone call was made, because I want to make sure that that's clear.
And is it also your position that if he had said, I don't want a discharge plan, and the doctor had said, well, I think that's a real problem for him to be released that discharge plan, he could recommit him for that reason?
No.
What's
No,
the
because
difference?
because
What's-
that's
what's the-
not,
what's-
that's
What's
not
the
new.
difference between the grandmother not coming and him not following the discharge plan?
Because in one instance, he has what the doctor feels is, although it's not ideal, he has a place to go to where he has a safety net, where he had been living from before, where the grandmother had been instrumental in arranging for the initial hospitalization. And if he goes back there, even though the doctor feels that that may not be safe, then it's at least something. And again, with reference back to the Department of Mental Health's regulations that speak to limiting under most, if not all circumstances, a discharge either to the streets or to a shelter, that if we change the facts around a bit and DL articulated that I don't want to go back there, I don't see how that would rise to the level of new information, which, again, if he said that, and if he were to step out the door of Pembroke Hospital, again, there is nothing that shows that any clinician independent of Pembroke, irrespective of the just denied petition for commitment, could have happened upon him and had his psychiatric hospitalization reapplied for.
And if he had said, if the discharge plan had said, take your meds, and he had said, I don't want your prescription, I don't want your meds, that would not be enough.
No.
So it's
No,
only-
because
it's only
because
because of grandma.
it's his presumptive, he's presumptively competent to refuse that medication. And again, what the hospital's position is based on new and added information.
There's new and added information that he's not going to take his meds.
But he hadn't taken his medication throughout the entirety of the admission, so that would not be new.
Oh, okay,
And
well, if he had been taking his medication, and then he said, I don't want the meds, you're saying that's now a change and you can do it again?
I don't think so, because what that's doing is, and again, it addresses the concern of folding in a potential risk of harm with a less restrictive setting. Here, it would be prohibitive of Chapter 123, because in that instance, you'd be folding in a commitment based on what otherwise would be a petition for treatment authorization under Section 8B of Chapter 123. So again, these are all situations where if the doctor had no idea about the discharge plan, or that there was no information one way or the other, and he wasn't operating on an assumption that he could go back to the grandmother, we wouldn't be here today, because he would have been discharged.
And what if he had said, okay, Mr. DL, you're discharged, and now I'm going to recommit you?
Well, again, that speaks to the questions and answers through Justice Lowy, where there are procedural safeguards that are put in place, so you can't have serial hospitalizations and rehospitalizations under Section 12B, because it would be deemed to be violative of DL's due process rights, or any other patient.
So he can send him to another facility, but he can't do it himself?
That's been made clear through this court's decision in McGreeny, where among the factual concerns was that the evaluation for the appropriateness of rehospitalization was done by the same attending psychiatrist who had been the attending during the just terminated admission. And so in order not to run afoul of McGreeny, I would suggest that hospitals would, among other things, not have the same attending psychiatrist conduct that re-evaluation.
But that wasn't-
It was his decision, though, to not release him and transfer him.
That's correct. To be subject to another application for hospitalization only after an independent evaluation.
I'm sorry, just.
That wasn't the that wasn't the linchpin of the decision in McGreeny.
Not at all, no, but that was among the factors where the court, in expressing that what had been done formed the appropriate basis for a request for an emergency hearing to allege that there was an abuse or misuse, was that the actual application for rehospitalization took place 15 minutes prior in time to the discharge from the earlier hospitalization, as well as the fact that he never left the locked unit that he had been hospitalized and treated on.
Right,
As
but
well as
you're
the
not-
fact that it was the same psychiatrist. So those form the basis of why it is that it would be an appropriate subject to request an emergency hearing that would prevent the district court to have jurisdiction to not hold the hearing itself.
Okay, thank you.
And thank you.